Thank you very much. I'm very grateful to be here, Madam Chairperson, President, Excellency Mrs. Aziza Baroud, for graciously hosting me and guiding our discussions today. I extend my gratitude also to the ACP Secretary General, Dr. Patrick Ignatius Gomez, and his team for making this meeting, facilitating and making this meeting happen. And for me, it is a great pleasure to be with you this morning. This is an esteemed assembly, and I'm happy that I'll have the opportunity to discuss with you today. I note with appreciation, of course, that 51 ACP states are part of the ICC. They're part of the Rome Statute, having ratified the Rome Statute. And I will, of course, encourage others to join the fight against impunity through joining the Rome Statute. And it is also my sincere belief that there is great benefit in greater membership of the court. For example, when considering the extreme forms of violence which plague our societies, and sadly, this same violence that cause enormous suffering to the civilian population, and it's from loss of life, loss of human life, loss of cultural life, to sexual and gender-based crimes, violence, and recruitment of child soldiers. All this is happening. And there are too many situations in the world today where very grave crimes appear to be committed, unfortunately, outside of the court's jurisdictional reach. So this means it leaves victims often with no recourse to justice. As we undertake our work, it may be clear, certainly, that we face many challenges, different challenges, and at times we face some serious setbacks. Certain court decisions, such as the recent acquittal of Mr. Laurent Gbagbo and Charles Blé Goudé, in relation to alleged crimes that were committed in Côte d'Ivoire, are indeed, for us, for my office, hugely disappointing for the victims and for the affected communities, those who suffered when these alleged crimes took place. However, while noting that we are seeking to appeal the decision, they also show something very important. It demonstrates the impartiality and the independence of the court and its judicial proceedings. That where every individual is given a fair trial and a meaningful defense. But then ultimately, we know that every situation, each situation is unique. And building strong prosecution cases against powerful people in difficult, politically volatile circumstances, with many interests at stake and with limited resources, is always a very complex and a daunting task. We therefore continuously look to build on experiences. We try to identify and to hone our best practices and strategies to improve our efficiency and ensure we have optimal impact over matters that we exercise control, matters that are in the control of the Office of the Prosecutor. And we believe this is part of our professional duty, and we encourage such an approach. But then justice for the victims, these victims of crimes committed in these situations should never be sacrificed at the altar of political expediency. This we need to always bear in mind. Exchanges, however, such as the one we are having today, as I said at the very beginning, assist us to be able to raise awareness and to also increase the understanding of international humanitarian law and international justice, including, of course, in this case, the ICC and the way the ICC functions. It is critically important to address persistent misperceptions, because there are misperceptions, and we hope that we will be able to facilitate this dialogue and discuss these misperceptions, because it also, perhaps lack of understanding and lack of awareness of how the court works does create this kind of misperceptions. So we will always be available to have this dialogue and to explain the work of the ICC. The Rome Statute that establishes the ICC affirms in its preamble that the most serious crimes of concern to the international community as a whole must not go unpunished, and that their effective prosecution must be ensured by taking measures at the national level and by enhancing international cooperation. And let me recognize in this context the important historical contributions of the ACP regions in the creation of the ICC. For example, in 1989, Trinidad and Tobago, on behalf of the Caribbean community, called upon the 44th session of the United Nations General Assembly to reconsider the establishment of an international criminal court. Trinidad and Tobago. And again, we recognize Africa's support in the period that was leading up to and during the Rome Conference, without which the ICC would never have been born, would never have been established. In fact, in February of 1999, it was Senegal, following the diplomatic conference also hosted in Senegal, it was Senegal that became the first state party to ratify the Rome Statute. And this is historically important step. It is a step that is hugely important one, symbolically, which was soon followed by also other states signing and ratifying the Rome Statute and becoming part of the ICC family. In the Cotonou Agreement between the European Union and the ACP, I have noted also that the ICC is rightly recognized as, and I'm quoting from that agreement, an important development for peace and international justice. Furthermore, if you also look at Article 7, Article 11, Paragraph 7, parties are encouraged to take steps towards ratifying and implementing the Rome Statute in addition to sharing experiences in the adoption of legal adjustments required. While my office, the Office of the Prosecutor, cannot and does not have resources to provide direct advice on domestic legislative initiatives or acts, we, however, stand ready to provide information on our work and functioning and to cooperate in concrete criminal cases with the national authorities where this is possible. In general, my door is always open for dialogue regarding all questions and concerns that states may have when it comes to the work of the ICC. Indeed, my office's open and interactive attitude is informed by the Rome Statute's guiding principles. First, complementarity. This means that states retain their primacy of jurisdiction and that states continue to bear the first responsibility to investigate and prosecute atrocity crimes, and to which my office, if possible, will defer to. Secondly, with cooperation. This requires all states that have joined the statute to comply with the court's request for assistance and support in the context of its investigations and prosecutions. So these two key features of the Rome Statute, that is complementarity and cooperation, it makes it unique, makes the system unique and dynamic, with the court interacting at various levels and in both bilateral and multilateral settings with a myriad of actors, including national law enforcement agencies, judiciaries, networks of specialized organizations, human rights, advocates, courts and tribunals, other rule of law actors, and academics and beyond. And this interaction starts at the preliminary examination stage, which allows my office to assess, if in situations, whether there may be a reasonable basis to initiate an investigation. We go through this process. And part of this process, my office determines issues of material and temporal and territorial jurisdiction, issues of admissibility, which relate to the question whether national authorities are dealing with the alleged Rome Statute crimes, and the gravity of the situation and matters of interest of justice. because where we find that national jurisdictions are dealing with the crimes themselves, the ICC will always take a back seat. And in certain situations under preliminary examinations, by no means, but by no means all, the need for us to assess this, the efficacy of the national jurisdictions, has led to the term that we call positive complementarity. And examples that I can give is Colombia and Guinea. These are situations where either war crimes or crimes against humanity have been committed, but where my office, through our engagement with the national authorities, and in conjunction with other regional and international actors, we have been encouraging domestic proceedings into these crimes. And through this engagement, we hope to ensure that the principle of complementarity can be successfully applied in these situations. And this may appear to take time. We know it takes time. But again, it is a very cost-effective approach that should be ultimately beneficial to victims and other stakeholders. And they represent a win-win outcome for all actors concerned. Even in the situations where the court does intervene and where the office conducts investigations with a view to gathering the necessary evidence, we continue as an office to collaborate with national authorities and with national actors. In fact, one of our strategic objectives, the office's strategic objective, is to promote the measure of coordination between the office and other prosecution of rule of law actors in an effort to close the impunity gap, which is particularly important when considering that atrocity crimes rarely occur in a vacuum, but rather in a context of wider criminality, such as transnational organized crimes, such as terrorism, such as trafficking of humans or natural resources, and also corruption or financial crimes. Libya is a case in point that I can give as an example, where we are now collaborating with prosecution authorities from a number of countries. And we share information with these countries and try to see who amongst us is best placed to address the crimes against migrants. This dynamic diversity within the Rome Statute system ultimately means that whilst the court will do its part to investigate and prosecute crimes where necessary, our impact and our success is actually achieving our goals to establish a culture of accountability for atrocity crimes, and it also depends on the level of political, diplomatic, operational, and financial support that we receive from states and other interlocutors. Many of the states that you represent here today have provided some meaningful and tangible support to my office and our activities, for which I am grateful, and I wanted to express that appreciation. Let me just give you a brief summary of the activities of the Office of the Prosecutor currently, our current cases and our investigations. We are currently involved in the trial proceedings against the Congolese warlord, Bosco Ntaganda, who is awaiting the verdict of the judges. The case, both the prosecution and the defense have closed their cases. The judges are yet to give their decision. There is also the case of Dominic Ongwen. He is the Ugandan warlord of the Lord's Resistance Army. He was a brigade commander, whose defense is currently responding to the case that is presented by the prosecution, by us. Another case, and that is Al-Hassan, relating to events in Timbuktu, Mali, is being prepared for a hearing to confirm the charges brought against him by my office. Active investigations are also ongoing in relation to a number of situations, including Georgia, Burundi, Mali, Ivory Coast, Darfur, and Central African Republic, Libya as well. And we are waiting right now for a decision from the judges concerning our request to initiate investigations in Afghanistan. Certain of our investigations should, we hope, come to a head and move to trial phases, depending to a certain extent on whether arrests of suspects can take place. And there are also examples are the recent arrest or surrender of Mr. Yekatom and of Mr. Ngaisona of the Central African Republic. However, 15 individuals for whom the ICC judges have issued warrants of arrest upon my application remain at large to date. They have not been arrested. And short of implementing these warrants, we have little chance to achieve the objectives of accountability and prevention. The victims who long for answers and who yearn for justice are those who will ultimately suffer the brunt of inaction. Investigations, you will note, seem to take a long time, may take a long time. We have in the past estimated that investigations should, on average, take about 3 years. But many factors affect how quickly we can come to a conclusion and how quickly we can bring charges. These factors, of course, include the complexity of the situation, the security that is on the ground during investigations, the level of support and cooperation we receive. We also have resource constraints, and we have other matters that affect the speed of those investigations. And as a relatively young institution, we are investing much time and effort in developing an efficient, professional, and sustainable office. An office which will be able to analyze critically our successes and our setbacks and makes necessary adjustment in order to both learn from the past activities but also to build on best practices. But notwithstanding certain court decisions, such as the mentioned acquittal or the appeal last year of Mr. Jean-Pierre Bemba for crimes by his MLC troops in the Central African Republic, I am and I remain profoundly committed to end impunity for crimes that shock the conscience of humanity. Let me conclude. I believe that the consolidation of peace and stability in a free and democratic society is one of the main ACP objectives. The Rome Statute crimes can undermine security and stability both nationally and regionally. And in this context, the ICC may play a crucial role in addressing impunity and achieving justice and reconciliation, and assisting states in developing their own national legal frameworks in order to address atrocity crimes. Ultimately, ending impunity and bringing justice to victims of atrocity crimes are not the preserve of any one institution. It is a common goal, and it is an aspiration that ties us all together in our shared quest for justice, for peace and stability, whether it is in Africa, whether it is in the Caribbean, or whether it is in the Pacific or in any other region. I thank you.